Good evening, everyone, and welcome to all those who are here physically present. Welcome to all those who are here with us via live stream from afar. Thank you so much for coming to a conversation that a week ago wasn't scheduled, but the news of the hour has prompted us to take a national conversation and bring it here present. I want to thank Rabbi Lori Kaufman and the entire programming team for making possible all of the arrangements that make this evening's program happen. I would say it's wonderful to welcome our guests, but you've been a member of Park Avenue Synagogue much longer than I've been the rabbi of Park Avenue Synagogue, so perhaps you should be welcoming me, Floyd. But just in case anyone who doesn't know, Floyd Abrams is a noted lawyer and award-winning legal scholar specializing in First Amendment issues. A partner at Cahill, Gordon, and Reindel. He is a lecturer in law at Columbia Law School and senior counsel at Cahill. Floyd has defended numerous clients in freedom of speech and press cases, serving as counsel to the Brooklyn Museum of Art in its case against Rudolph Giuliani. He's the author of 3 books, The Soul of the First Amendment, Friend of the Court on the Front Lines with the First Amendment, and Speaking Freely. Floyd has a national trial on appellate practice and extensive appellate in high visibility matters, often involving First Amendment, securities litigation, intellectual property, public policy, and regulatory issues. He's argued frequently in the Supreme Court in cases raising issues as diverse as the scope of the First Amendment, the interpretation of, I don't even know what this is, ERISA, E-R-I-S-A, that you'll explain, the broadcasting regulations, the impact of copyright law, and the continuing viability of the Miranda rule. There's a much longer bio here. The most important word is that he's a proud member of Park Avenue Synagogue. Welcome, Floyd. Floyd, I notice your tie is a tie with the signatories, to the framers here, and an appropriate way to begin the evening.
And a special tribute to Thomas Jefferson,
Very nice.
Without whom there would be no Bill of Rights.
Okay, that's not actually Jefferson's tie. No. Could be, that would be something. So, Floyd, can you recite the First Amendment off by heart? I wrote it out here. Can I read it, or do you want to check?
Why don't you read it?
Okay, you tell me if I get it right.
Yeah.
Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Did I get it?
Got it.
Okay, so here's my first question for you. All of our attention is on what's happening on campuses right now. The First Amendment, as I just read it, says Congress shall make no law. When did private universities become Congress?
Private universities are not. Congress became the state, and in certain cases, even more than the state, but generally the states. So the First Amendment protects us against the government taking away whatever the words freedom of speech or of the press mean. And that's been read expansively through the years. So yes, it's the government. Sometimes it drips over into other areas, but the core of it is a protection against the government depriving the people of their rights.
Okay, so for those of us whose legal background only involves an ill-fated 3 hours taking the LSAT and done, the difference is what? When we're talking about what Congress does, what public university, because we're going to focus on universities and campus,
Okay.
and what happens in terms of public versus private universities. Is it the actual letter of the law, or is it the spirit of free speech discourse at stake?
It's complicated. Now, it's state universities are governed by the First Amendment. So any university, SUNY, is a state university. University of California in Berkeley is a state university. And at the beginning, at least, that was it. It meaning only state-owned entities. But with universities, that has spread in some places in the country. California and New Jersey, for example, have both said that their own First Amendment, states have their own protection for the citizens, irrespective of what the First Amendment is. New York State has its own First Amendment, and all the states have their own. And at least in 2 states, California and New Jersey, they've just applied their own First Amendment in a way that encompasses all universities in the states. More than that, many, if not most universities, get money from the federal government. To get the money, they have to promise to abide by the Constitution. So, although it sounds as if it applies with respect to only state universities, it has a lot of application. That does differ state to state, but a lot of application to universities, and basically to just about all the great universities, the names of which come to mind for us and that we'll be talking about here. I had thought, for example, at the university, all my life, I thought the University of Pennsylvania was a state school. It is not. It's a private institution, just like all the other names of colleges that we'll be talking about here. But either the text of the First Amendment as interpreted or the spirit of the First Amendment will have a lot to say about what is allowed and not allowed, what is protected and not protected in universities.
Okay, so let's get to the news of the week. So what actually happened this week? The now viral congressional hearing of it all depends on context, whether students should be disciplined if they call for genocide of the Jews. Can you unpack for those of us what happened?
Congress is having an investigation. One may think it's none of Congress's business, and believe me, the universities think that way. They're not happy when they're called to testify, but there were hearings, and the hearings were about whether the great universities that were represented at the hearings were abiding by either the First Amendment as a matter of law or what I would call First Amendment norms, the policies of the First Amendment, that which there have been cases already determining that universities can do this and not do that. So it is not entirely clear because it is different as a strict matter of law in some states from other states. But certainly the hearings here just assumed, not unfairly, that the First Amendment governed. I'll leave out motivations for the hearings and everything, but on the face of it, the hearings were about whether a number of our great universities were abiding by the First Amendment.
So what the question
Right.
of should students be disciplined calling for the genocide of the Jews,
Right.
and the response given to the Representative Stefanik that
Right.
it depends on the context.
Right. So,
I mean, do you agree? Were they legally right, and were they morally right?
yeah. Well, they were certainly morally wrong. on a I mean, to be fair to the former president of the University of Pennsylvania, there were things in her prepared testimony which did say, in one way or another, that we protect freedom of speech. But the way I view this, let me put it this way, is first I view it historically. I mean, when I was in college all those years ago, I went to Cornell, and apart from a particular part of Cornell, it's not a state school. And when you became a student there, they gave you a card. The card said on it, you know, here's your name, here's your picture, do what we tell you. And if you don't have the card with you, we can throw you out. And if you violate the card, we can throw you out, et cetera, et cetera. They're developed through the years, and through more recent years than not, much more direct application of the First Amendment to what occurs on campus. Let's make it easy. May a state university dismiss a professor because he or she voted for Biden or Trump? No. That violates the Constitution, violates other things, but it violates the Constitution. And so questions were asked that they were meant to embarrass, and they were enormously successful in embarrassing. Questions were asked about the abiding by the First Amendment, or what may be the First Amendment, in these schools. And it arose in the context, as you said, of some signs around urging the genocide of Jews around the world. Now, to go back to when I was in college, they would just throw the student out. I mean, it wouldn't have been allowed. And if they insisted on putting it up, there would be sanctions imposed. The First Amendment and the equivalent of the First Amendment for all these great universities does allow a very high level of advocacy. Not something that would interfere with classes as such, but you know, who to vote for. You know, maybe not in this room on these hours, but as a general matter, what I will call political speech, read very broadly, not just who to vote for, but what to think about public matters, is protected in general. And so what the woman who was the head of the University of Pennsylvania was saying, her lawyers with whom she and the others had met had obviously provided the words, is that it depends upon the circumstances. And of course it does, but of course there couldn't have been a worse answer. I mean, remember, the question was, what about...
So if I was hiring you,
yeah,
what would have the right answer
the first
been?
line had to be, this is disgraceful, this is anti-Semitic, this is unacceptable. I'm not answering yet about what the law is. I'm saying how I feel about this. And she failed in that. I don't know, you know, if her lawyers had told her, just answer the question. Because what I'm saying was she shouldn't have just answered the question. She should have started on a human level of saying in the clearest, least ambiguous way, this is an outrageous expression. Now, if you want to know, is that nonetheless protected on this campus? I mean, if she were speaking the literal truth, she would have said, because my lawyers said that I should say that it is based on context. There are circumstances in which, of course, that speech would be unacceptable, but it depends, it depends, it depends. Now, the problem with that is that it sounds, and it sounded, unfeeling, uncaring, prepared to accept this awful sign without even shedding a tear, without even saying, assuming that her articulation on the law was right, without even saying, this is terrible. I want you to know how badly I feel. It hurts our students, it does this, it does that. And it was, you know.
But isn't Penn, you just pointed out that despite its name, Penn is a private university. Right. So leaving aside the sort of aesthetics and the poor choice of words and the ill-advised counsel that this person got, by a letter of the law, right, the University of Pennsylvania is operating by its own rules as a privately funded university, and whereas they might take upon them a speech code involving free speech, they are actually able to set the rules in a way different than, say, UC Berkeley or University of Michigan. Correct. Is that correct?
Yeah, that's right. Okay. Now again, the law has been moving in more recent years in the direction, without quite saying it, of applying under Pennsylvania law or the law of the states, the application of the First Amendment. I mean, one way to think of this on a large scale is the First Amendment protects a lot of terrible speech, dangerous but not dangerous enough to make illegal, offensive but not so over the wall that the law has banned it. And one of the reasons the law doesn't ban it is that, depending on the circumstances, it can be protected. So it sounds like an easy question. I was asked by what I'll call a First Amendment friend of mine, would I join him in writing a letter to the New York Times denouncing the senator or congressman for asking the question, which the answer is, no, it's not the most outrageous question, but more than that, I didn't want to join because I thought that her tactical error of not starting by denouncing and disassociating herself from this awful speech made any answer which sounded like it's okay with us sound horrible. And the lesson, when I would talk to let's say I had a client next week in a situation like this, I would say the lesson you have to learn is that all the things I've told you, what the law is and the like, you have to retain your humanity. And you have to sound as if, as I'm sure you are a person who finds it horrible that anybody would choose to say these things. But as a matter of law, I might well say exactly what she said.
But I don't understand why calling for the genocide of Jews or anyone is not just off limits, right? Because it seems that there are two competing impulses here. I'm trying to go to first principles here. Right. You have the ideal whether legal or in spirit, of free speech, right? The freer the speech, it's a good thing. And yet you also have the ideal of safe discourse. No one should be harassed because of their ethnic, religious, or whatever Title VI says, that there should be some sort of safety guardrails to people feeling. And when someone calls for my death, that strikes me as a form of harassment.
Yeah. Look, and I can, well, we all can, can see the strength of that. The legalistic answer, I would say, is that as a general matter, just about any statement that does not lead to immediate harm, if not, you ought to take your gun out and shoot the person in the next row. A statement about what ought to happen in the world is protected by the First Amendment, and it is. And as a general proposition, that sort of language would be protected. Now, if the position of the school was, we can't teach in an atmosphere in which language like that is voiced, because our students can't, or our Jewish students, or our students who care about life one way or the other, can't function with that sort of verbiage around, that would then go in the courts for a decision about whether that argument passes muster. But at the broadest level, I mean, the First Amendment really was meant to protect bad speech as well as good, and even offensive, terribly offensive speech. The First Amendment issue is more often level of danger of the speech.
Can I ask on that? Are there gradations there, meaning students marching through with a placard saying from the river to the sea versus someone putting up a poster on a campus bulletin board versus someone tearing down a poster on a campus bulletin board versus someone putting that on the door of a Jewish student's dorm room? Are these different levels of threat that exist in the law?
Absolutely. I will never forget, I did some work for Yale some years ago, and I had a call from the president of Yale. A white female law student had been raped in New Haven by a black man, and the next morning on the door of every black law student was something posted saying, now you know why we call you the N-word, every black student. So I had a call from the president of Yale saying, is there a First Amendment objection to my calling the FBI? I'm the arbiter here. I mean, is this something which allows the calling in of the police onto campus, into dorms and the like? And I said, yes. I mean, it is allowed to call the FBI, and the FBI can investigate, ask questions properly and all that to try to find out if this was maybe a student who did this, because that sort of implicit but very real threat to have this on your door when you wake up and it's racially directed was something that was appropriate to look into. And the other way to say that, not about the law of it, is that it would be terrible if Yale did not do whatever it could to find out who had left these threatening statements, which themselves were not, I mean, certain threats are not protected by the First Amendment. Now, was this a threat? I thought there was a threat. The president of Yale thought it was a threat. Implicit, yes, but all but explicit. And it took a long time. I think they found whoever did it. But,
okay. By the way, this is like if I were to be playing a pickup game of tennis with Pete Sampras here. I just get to ask you all the questions that I want to ask. And we'll open it up in about 4 minutes, so have your questions prepared. And I always would rather call on a college or soon-to-be college student first, so get your questions ready. Is there a difference between political, I mean, let's remember, we're in the wake of October 7th here. And so whether you're protesting the action, you frame your free speech as against the state of Israel versus against Jews. Now, ever since Genesis chapter 12, Jewish identity has been tied into a connection to a land. So even we Jews don't quite know where our religious identity starts and our national connection begins. But the specific question is there a legal distinction between any of these free speech issues as it relates to anti-Israel versus anti-Jewish in the eyes of the law?
There is no clear answer. My sense is that calling for the destruction of Israel would probably be held to be protected speech, notwithstanding all that is encompassed in that. Calling for the death of all Jews at least can be different. I mean, it is different in its nature. A more specific threat to Jews at this college is, in my view, in all probability, really over the line into being a threat to me sleeping in my room because I'm Jewish. But a broad statement, and most democratic countries would not go this far at all. I mean, countries that we care about, who care about free speech, we do provide more protection for free speech and free press than is true anywhere in the world, including democratic countries. And that's the way our law has developed. You could say, I mean, think of the language that the rabbi read at the beginning. I mean, it's just a few words, right? And the speech and the press side is not even a full line. Congress shall make no law abridging the freedom of speech or of the press. You want to know what word in that lawyers and law professors in particular, and some Supreme Court justices look hardest at? Again, the language. Congress now meaning the states, shall make no law abridging. It's a word you have to know what it means. The law has to tell us. The freedom of the. In my law school class, we spent 2 days on the word the, because our professor was saying the freedom of speech could mean the way it was in England. The freedom of speech together, the words together, can be a particular concept of what speech is. They didn't have to use the word. They could have just said freedom of speech. That's how those are the games that we play. And it's very, very important in terms of how cases come out, depending on what sort of textual analysis you or the courts give to particular language. I mean, I'm heading right now at a 2-year study of the press clause. Those very few words at the very end of the line that both of us have now read to you. Congressman, no longer abridging the freedom of speech or of the press. Well, now here we are in the 21st century. Is social media the press? What is the press? Does it have to be something that people are? I don't want to make it sound just like journalists running around, but does it have to have an element of human activity, or might it be something which comes into being because our technological abilities are such now that we don't need people at all? So we're spending a lot of time having conferences with scholars talking about what the press should mean, particularly in a century in which more and more people get their news or other information from sources other than newspapers. And that's something that the courts have to deal with all the time in different areas. I mean, they used language, 1789 when the Constitution was the Bill of Rights was drafted and adopted, that we have to to do our best to apply in the new world. I used to have cases about radio, television, a lot of television cases.
So maybe one of those present, or maybe if we have time, I'll ask you specifically about social media and platforms like that. But let's open it up, and I remind everyone that a question is a short statement with a question mark at the end of it. So do we have any young people who are on campus or about to go onto campus? Neither you, or you fall in that category. Anyone here? Yeah, please, and go ahead.
Stand up. So I want to go back to one of your earlier points where you were giving advice to the rabbi on how you would counsel him. And the answer should have been, it's not, but it should be. Like if the university presidents were to say, on a moral basis, this is completely unjust, but it is legally allowed at our campus, is there any legal grounds to change that? Would there be, notwithstanding the Title VI, which is a separate but attached issue, could you change that sort of thing without going against the First Amendment of each state, or Pennsylvania or Massachusetts, for example?
Thank you.
That's a very good question. Or of course, the U.S. Constitution itself. And the answer is no. Or put it differently, the answer is whatever the Constitution means, it means. Whatever the judges say, the Constitution means as regards a particular topic is not movable. And now I have to say, and not joking, unless it is. The world changes. We're, again, on the project I'm working on, we're spending a lot of time thinking about and talking about, does it have to be on a piece of paper? I mean, they use the word press. What are we talking about? One example that I often have cited is Reader's Digest, which used to be the best-selling magazine in America, a magazine which simply published articles already written elsewhere. The 30 articles that you ought to read this month, one a night. And they got permission, of course, from wherever the writer came out. Now, and my point in citing it to my friends on this matter is it the press? Are they the press? They aren't writing anything. They're not only not doing the work, right. They're not authors, but they are engaged in a selective process of what to print. You know, my answer is and I know some cases even, they were treated as the press, even though they didn't do the press work that we think of.
All right, let's just get, I think that was the young person. So you are young at heart in the middle. Thank you.
For the young at heart part. I'm an alum of both MIT and Harvard, so I've been embroiled in all this for some time, even before the testimony. And most of the discussion was academic freedom rather than the First Amendment. But the dean of the med school sent out a letter appropriately castigating the massacre, and that he was saddened by the fact that a group of medical students had signed a document applauding the massacre. In the context of what you were talking about with discipline, considering there are certain, the medical school makes clear there are certain behavioral expectations of physicians.
Yes.
I sent an email back to him saying,
I want a question, sir.
How can you justify training people to become physicians who celebrate a massacre? Given the context of the expectations of physician behavior, would there have been justification for the dean to eject these students from the medical school?
I hope this is the direct answer. If they forced the doctor or medical student listeners to say anything, that's not protected. If they, in effect, simply force the person to listen, I think even that, by some sort of threat or even an implied threat, that wouldn't be protected. Beyond that, the speech itself is more likely than not protected, but the conduct attendant to the speech would not be.
Okay, let's, in the back there, ma'am.
Thank you very much for talking to us. My son is a sophomore at the University of Vermont, and there have been various protests, and one of them was in front of the Hillel building, where he also happens to live. And I'm wondering if university administrators were really interested in lowering the temperature on university campuses. Wouldn't they be able to say about this entire issue that there were time, place, and manner restrictions? Like you can't protest here either way, or protest must be here at a certain time, if they were really interested in lowering the temperature while protecting free speech?
I think I was about to say certainly, which is ridiculous, but it certainly would be a time, place, manner restriction to limit take an easy case, speech at 2 a.m. in the morning, which keeps people awake. That sort of thing has never been held protected. And we've had cases, sound trucks, let alone speech of the sort that you're talking about. Beyond that, the fact that it's outside a medical school would not change the dynamics or the application of First Amendment law. Obviously, if it could be said to interfere with medical treatments with a hospital, of course, that can be limited anywhere. Anywhere at any time that's rational in our country. But the fact that it's, what should I say, unpleasant for the potential listener or off point in the sense that the listener doesn't want to hear about that topic would not, as a matter of course.
Free speech is free speech. If there's a protest going on Yom Kippur when all the Jewish students are in the Hillel versus on another, or we're just free speech absolutists that...
No, I don't know the answer to that. That's a good question. Thanks. No, they could certainly keep them away, I think, in that situation from the area in which students were praying. But it's hard to answer beyond that. They would certainly not be able to sort of shut them up on the ground that it interferes with prayer or contemplation or the like.
Okay. There's another. Emily, can we, sorry, I don't mean to, you have a full few moments to gather your thoughts, to think exactly what you want to say, and here we go.
Hello, I'm Emily Adler, and I wanted to ask if there could be a way to consider the words of George Washington and his concern about the Jews when applying the First Amendment. Because he had a special concern, and he addressed a congregation in Rhode Island that the Jews should enjoy the same goodwill from others, that they shouldn't be afraid, religious tolerance, and all of this is being violated on the campuses. And he is our founding father.
I'm afraid not. That sort of language, meaningful as it is, would not easily be a basis for limiting what would otherwise be protected speech. I mean, particularly in a situation where Washington was speaking generally about how a country should work, how people should behave. It wouldn't by itself carry the day against whatever it is that the First Amendment allows and protects. I would like to say before we leave, and you think that we're all doomed to a society in which awful speech prevents us from living a better life, that the theory of the First Amendment does include the notion that there will be some speech which is unpleasant and even painful, which we do protect for what is viewed, at least legally, as the greater good of preventing government control over what people think and say to others. I mean, a lot of speech is understandably offensive to other people, and there are some circumstances in which the offense is so great and the ease of speaking elsewhere is so easy that, back to the Yom Kippur, that you can, I'm confident you can keep people screaming outside a synagogue, away from the synagogue. But where it's the more commonplace sort of speech, where the objection is the words, what the words convey, we do provide enormous protection for speech because of our concern about the enormous risks of allowing the government to control it.
Okay, we'll do one last question. I'm so sorry, Rabbi. Normally we have two mics, so I'm just, so Sir Bryce. This I think will be our last question, unless I want the last one.
Two quick questions just on the law. Thinking about the past precedent that some of these universities have curtailed speech, what's the statute of limitations on going back in the past and saying, this kid was kicked out for, this violation of speech, like how far back? And the other one is, if a university said to a kid that was marching, calling for genocide, and called a violation, and they were ultimately wrong. What's the harm to the university? Like, what happens to the university from violation of free speech, 2 years forward or whatever it is?
There can be damages awarded. One can bring lawsuits for financial loss. I mean, it doesn't have to be out-of-pocket money, but the level of harm inflicted on you from speech. Mayor Giuliani learned today that he's supposedly in the soup for $142 million, but I just couldn't not mention it.
Okay. Friends, I think we are out of time. In approximately 8 minutes, Floyd Abrams just becomes a private Jew sitting in synagogue. So I will give everyone a moment once the program concludes to ask whatever questions you want if you really want your free speech rights protected here. But at approximately 6 o'clock, free speech ends, and we will begin services promptly at 6:15. Please join me in thanking our scholar, our guest, Floyd Abrams.